We've explored how title and escrow function, the laws that govern them, and how agents can resolve problems that arise before, during, and after closing. Now, in this final chapter, we'll bring it all together by focusing on ethical practice, professional conduct, and compliance, the foundation of trust and reputation in Arizona real estate. Understanding title and escrow isn't just about process, it's about professionalism. Every decision an agent makes in communicating with clients, handling funds, and representing facts reflects on their integrity and adherence to the Arizona Department of Real Estate ADRA standards. The ethical foundation of title and escrow. At its core, real estate is built on fiduciary duty, a relationship of trust and confidence between the licensee and their client. Under Commissioner's Rule R4-28-1101A, agents must protect and promote the interests of their clients while dealing honestly and fairly with all parties. When working with title and escrow professionals, ethical practice requires transparency, disclosing all material facts that may affect the transaction. Integrity, never misleading a client about title, escrow, or closing timelines. Accountability, taking responsibility for communication and documentation. Competence, understanding and explaining the process clearly and accurately. Example, a Glendale agent learned from escrow that a small tax lien appeared on title after the inspection period. Instead of downplaying it, the agent immediately informed the buyer and seller, explaining that it could be cleared before closing. This honesty built trust and prevented a last-minute panic. An example of compliance with R428-1101E, disclosure of material facts. Avoiding the unauthorized practice of law agents often face questions about legal documents, ownership disputes, or title defects. While agents must be knowledgeable, they are not attorneys and cannot offer legal opinions or prepare legal documents beyond standard real estate forms. According to R428-1101K, a licensee must recommend professional advice when the client's questions go beyond the agent's expertise. That means referring clients to an attorney, title officer, or escrow manager when needed. Example: a Phoenix buyer asked an agent to draft language for an addendum regarding lien removal. The agent wisely advised the buyer to consult the title officer instead of guessing the legal phrasing. This protected the agent from liability and complied with ADRI's ethical rule. Proper handling of earnest money and escrow funds. Money management is one of the most sensitive and regulated aspects of real estate. Under R428-802A and ARS, paragraph 32-2151.01, brokers and agents must deliver earnest money, checks, or other funds promptly to escrow and maintain proper records for at least 5 years. Agents must never hold earnest money in their personal account, release or redirect funds without written authorization, promise outcomes about fund release before escrow confirms compliance. Example: a temp agent mistakenly held a buyer's earnest check for 3 days before turning it in. The broker self-reported the late delivery to ADRI and instituted stricter office policies. The agent learned an important lesson in compliance, reinforcing the importance of timely handling of funds. Ethical communication between parties. Ethics extends beyond law. It's how agents communicate, follow up, and collaborate. In the title and escrow process, this includes keeping clients informed about key dates, KOE, inspections, recording, responding promptly to title requests for documents or signatures, avoiding he said, she said conflicts by maintaining written communication trails, respecting confidentiality, never sharing another client's information with a third party. Example: in a Queen Creek sale, 2 agents clashed over closing delays. One accused escrow of holding up the process. Instead of escalating tension, the listing agent calmly verified details with the escrow officer and provided clear factual updates to all parties. The situation resolved without conflict, and both clients praised the agent's professionalism. Legal and ethical boundaries. Gifts, referrals, and RESPA. The Real Estate Settlement Procedures Act, RESPA, strictly prohibits giving or receiving kickbacks or referral fees between real estate licensees and settlement service providers, such as title or escrow companies. Violations can result in fines up to $10,000 per occurrence and disciplinary action under ARS paragraph 32, 2153IA 3. Acceptable practices include modest marketing materials, pens, notepads, coffee, under $50 per year. Jointly sponsored events where costs are proportionally shared. Transparent business relationships fully disclosed to the client. Example: a lender offered an agent a $500 gift card for referring buyers. The agent declined and reported the offer to their broker, avoiding a RESPA Section 8 violation. Ethical choices protect not just your license, but your reputation. Key takeaways. Ethical and legal best practices are the heart of successful real estate. Arizona agents must demonstrate transparency, integrity, and accountability in every title and escrow interaction. Complying with R428-1101, R428-802, and ARS, paragraph 32, 2151.01, ensures professional conduct and client trust. When in doubt, agents should always disclose, document, and defer to qualified professionals.